as Jacob said, Brad and I and the team, we try to be very thoughtful on the topics that we address every year. And it only took us, how many years to realize that we have not done a litigation support topic. It probably is the more exciting part of our practice. So met with many, many stories, which the time does not permit me to share with you guys today, but try to give some examples as we go along. So just a little introduction. When we're called to do this type of work, it's typically in I'll say 3.5 buckets, and you'll see the half. So typically we're solving for damages. It can involve lost profits. It can involve lost value of the business. But in any juncture, we're called in to quantify what some type of loss is. Another area of our practice is shareholder buyouts, which become contentious, and we also call them shareholder divorces because very much like a regular divorce, they're very hot, contentious, and very difficult to parcel out. And then lastly, another bucket, which often is an outgrowth over a shareholder dispute, is the notion of shareholder oppression. And that's a situation where a majority shareholder or a group of majority shareholders effectuate some type of oppression over a minority shareholder or group of minority shareholders. And then when I say half, we do some work in family law. So we will do some real divorce work. Typically when there is a large business and a large contingent of assets that are at issue, we'll go ahead and do that work. So this type of work is a partnership between an attorney and with us. Unlike an attorney who is there to advocate for their client, we are there to advocate for our position. So very different. We are there for the trier of fact rather than to advocate for the client. So just to give you a little example, right now I had a bill that was probably 2-3 months in arrears. In order to permit me to be deposed in 2 weeks, that bill has to be paid. The reason why is I can't be seen as having a position of advocacy, like I'm going to do the best job I can to get paid for these people. So it's a very different look, and it's a very different when you think about litigation type of way to approach that from a financial expert point of view. But so the role of financial expert is going to be determined at the inception. We can act as, did I advance the slide? We can act as consulting experts or testifying experts. Consulting experts, that's more fun. You can assist the attorney with some pretrial matters. Our work is protected, so we can go in and do some valuation work and do some calculations, and if the attorney likes what we're saying, they would keep us on or go with another firm, another evaluator. Expert testimony, that's obviously when we're expected to provide some form of testimony to support our conclusions. That work is discoverable under federal and state rules of civil procedure. We need to be careful to make sure that our testimony is going to be admissible. So we have to comply with our professional standards, any case law and evidentiary standards that are related to the admissibility of our testimony. That typically is advised to us by legal counsel. We do a lot of work in Pittsburgh and surrounding areas, but currently I have cases in Maine, Michigan, cases in the South. So we go everywhere, and we are typically advised by legal counsel as to what the standards are in that particular jurisdiction. But financial experts, we have to be qualified, we have to be knowledgeable and trained and have experience in our field. So we stay in our lane, and our lane is to do those things that we talked about on the first slide. We provide facts, assumptions, information, and other considerations to the trier of fact to support our conclusions. And then certainly we are there to walk through the methodologies that led to our conclusions. So just to lay the fundamental groundwork for lost profits determinations, there are 3 key elements that we are woven into in a non-advocacy type of way. We're there to be objective. So lost profits need to be proven that they were directly caused by the opposing parties. So the wrongful actions need to be proven to be caused by the defendant in a case. So causation has to be established. It also has to be established that the lost profits were a foreseeable consequence of the defendant's wrongful conduct. And then lost profits must be determined and proven with reasonable certainty. So there are three buckets that the attorneys have to prove the trier of fact. Trier of fact could be a bench trial, a judge, or it could be a jury. And they have that task to prove those things in support with us. So how do we calculate these things? Lost profits are computed as the amount necessary to restore the injured party to the position he or she would have been had the injury or incident not occurred. So your lost profits are going to be your lost net revenues less any avoided costs. So it's important to understand what costs did we avoid during this damages period. And then there are various approaches and methods which I'll talk to you about that you need to plug and play based on the specific circumstances of the project. My team will probably attest to this. Every time we go through a case, it requires contemplation of so many elements which are germane to applying the methodologies with the data that's available. And it's also a constant challenge to be thinking about, well, if I'm on the other side, how would I challenge this? So I become a little bit schizophrenic because I hear all kinds of voices when I'm going through this. Well, how can I challenge this? Should I be doing this? One of the things that's what's very difficult is calculations should not be based on speculation, but they should be based on reasonable and reliable factors. And then there has to be adequate support. So it's very difficult when we're in the realm of our litigation support practice to listen to plaintiff highly charged, emotional, and then a lot of that blurs the lines between what's truly of substance here and what's truly speculation on the part of the plaintiff. Oops, sorry. So just some of the considerations is the plaintiff has to prove that, and obviously it's going to be the plaintiff's counsel, has to prove that the acts of the defendant caused damages to the plaintiff. The defendant has to be a material factor in the case. They might not be the sole reason, but they have to be the most material factor in terms of the damaging event. We also have to look for or consider other aspects or other factors that may have contributed to the damage or the cause of the plaintiff's loss. The easiest thing is during COVID and the aftermath of COVID, a lot of businesses were damaged. We had PPP, we had all these, all of this financial support, and there are some damages cases trying to flutter about, but the difficulty in that instance was that damage mostly caused by the defendant, or is it mostly caused by something that was beyond their control? Not being able to fulfill a supply contract, something like that. So failure to address relevant factors obviously can cause us to be negligent or fail certainly on the part of proving reasonable certainty. So there will always be a period of damages. Obviously, the start date is when the harmful act occurred. That will be the date at which we start looking at damages and going forward. And then the end date, and sometimes when we're working on it, the end date hasn't happened yet. The damages period is ongoing. That's the point at which the plaintiff's operations return to normal if we have that bookend to a damages period. Brad will talk about loss of business value when we do the valuation side, and that's definitely when damages continue to be ongoing in a shareholder case. So from a high level, approaches that we can use a one model approach that basically is a calculation that considers only the incremental lost revenues and related avoided costs with respect to that damaging event. There's a two model approach, which we take the difference in the net profits the business would have attained but for the damaging event and the actual financial, and then we contrast that with the actual financial results, and the delta being the actual damages that were sustained. So from a high level, I'm going to go down through the models that we use or that are available to us. There are 3 out of 4 of these we use very frequently. The last one I'll describe as in a little bit of a different context, but we've had to use it a time or two in the past. This notion of the before and after method, we talk about it's more of a bookends method. It compares performance of the business prior to the alleged action and then the after effects of the damaging event. So we look at history, and this works well obviously when the company is in business and has a track record. We understand the notion of an alleged event, and then we look at, okay, what has happened in the aftermath but for the actions of the defendant. So this is obviously, as I said, best applied for an established business with a historical track record. But this method actually can also be used by the defendant to illustrate that the plaintiff didn't suffer any harm. And that could be in 2 ways. The plaintiff, one, was able to mitigate their damages pretty quickly. They didn't like to have to shuffle to do that, but they went ahead and did that. The plaintiff can prove it that way, or the plaintiff can prove that the financial situation of the company did not significantly decline and was not attributable to their actions. And as in every aspect of the calculations that we do, every method that we apply, we have to consider other factors that may have contributed to the damages or the loss. Yardstick method, we do use this, and this is known as benchmarking. So when we do a typical valuation and we want to understand, well, what's the industry saying for gross profits? What's the industry saying for gross margin? This is the same methodology that's applicable for damages. So if we have a situation where we don't have significant history, or something was not presented on a normalized basis in most recent history, we'll look at this benchmark method. So we'll go to look at guideline industry measures to determine what the revenues and profits of the company would have attained if the damaging event hasn't happened. You can use outside companies as guidelines, or even proxies from within the company. And when I say within the company, they may have another operating segment or another subsidiary that is very similar that you can use that as a proxy, that hasn't been damaged, and you can use that as a proxy. So the challenge there is, if you're on the other side, it's always, well, is the information that you used and the companies that you used, are they sufficiently similar? And so that's a hurdle that we have to cross in everyone. And we just, when we go through this, you're never going to find an exact fit. It just has to be sufficiently similar to pass the minimum benchmarks of the court. And obviously considering other aspects that could have caused the damage. So the sales projection, or just a general forecast method, this we only use if that forecast was prepared prior to the damaging event. So businesses might budget, they may prepare 2-3-year pro forma. If that is done, that is something that you definitely want to use, because this was based on their knowledge, a certain set of assumptions, but prior to the damaging event is key. There are experts that will use forecasts after that were prepared by management. If you're not diverting back to the yardstick method and kicking the tires on that, that's going to be a pretty big issue when it comes to the finder of fact. But it can be, this can be difficult to identify and measure some other effects that would impact the underlying projections of the business that would happen after they prepared the forecast. So there is a market multiple. And this we see a lot of times it's on the slide, patent infringement cases, because it deals a lot with market share. So what we're looking at is the plaintiff's market share prior to the alleged act to help determine those lost revenues. We must define certainly the market of the company and analyze the subject business's historical sales, and as well as they performed versus their competitors. This gets a little sticky too, especially in patent infringement. After the damage event and over the damaging period, you need to make sure that you don't have entrance of competitors and other factors that would have weighed on or factored into the performance of the business and not solely attributed to the damaging event itself. So we talked about looking at the revenue side. We do have to dig deep in this aspect of avoided costs. So basically this is tearing apart the P&L with the expense section. We bifurcate between what's a fixed cost, what's a variable cost. So if you think about it, if a business has to pay rent no matter what is going on in their business, that's a fixed cost. That's not something that's going to be recoverable. It's those variable costs that, well, if we don't have widgets to make or something to make, we are saved from bearing that cost. So we will categorize all of the costs of the business and plug the relevant costs into the section of the calculation, depending on which method will be used. Typically, when we have a damaging event and we have damages that are going to go out into the future, we are going to have to present value those back typically. Beyond the scope of this talk today is going to be application of discount rates. But if you remember some of our prior talks on income approach and discounting future forecasts back to present value by the risk, that's basically what we're looking at. We're looking at the time value of money, and we're looking at risk. So one of the other aspects that we have to decide, and not typically at the outset, because when we work on these engagements, they're pretty fluid. Facts change, depositions are taken. So I'm getting deposition transcripts and things that I thought we understood would be a fundamental assumption in our analysis has now changed. Additional information is brought to light. So this is a very fluid process, but we look to, when we're calculating damages, are we going to do them ex ante, or are we going to prepare them on an ex post basis? And sometimes we've employed a hybrid, but ex ante basically is going to use estimates at the date that the damage happened. So they're going to use estimates for future income and expenses before actual results are known. So they're going to start looking at the date that the wrongful event happened going forward. And the calculation, as it deals with prejudgment interest, which is allowable in all jurisdictions, the application of that is done at a very different time than if we're doing ex post, because we're actually looking at post-damage, what has happened to the business, if that makes sense. Ante is at the date that the damage starts, and using assumptions for the future, and ex post is, well, we know when the damage has started, but we want to know what actually happened, if that makes sense. Taxes, these calculations are done without consideration of tax. Typically, damages awards are done on a pre-tax basis because they are applied to, or ordinary tax rates are applied to any damages award. In a loss profits situation, in any commercial type case that we work on, that's true. If there is a wrongful death case, which we have worked on things like that, those damages are typically not taxed. And in terms of a big aspect of what we do, mitigation is huge, because we have to consider what has the plaintiff done, the foreign plaintiff side, what has the plaintiff done to mitigate their damages. They have to, courts, it's a must. Courts have to see that you've tried to mitigate your damages. If not, that definitely weighs on any damages award that the trier of fact would award. But plaintiffs generally cannot recover damages that were foreseeable and could have been avoided by reasonable efforts without causing undue risk or expense. So what we look at are these buckets here, and we also kind of frame things around these factors and their ability to mitigate. If the financial cost to mitigate is too great, let's say the client has lost their main customer. If the ability to mitigate financially is too great, that is factored in. If the cost to mitigate as compared to the overall damages is suffered by the plaintiff is great, that's a factor. Technical barriers to mitigation. And that could be, we've had a case where employee was paid to develop proprietary know-how. Thus, that know-how stayed with the company. However, when the defendant left, he took the proprietary know-how with him, went to the main competitor, and started working. So that's a damages case that we have worked on. So our client had certainly technical barriers to mitigation because the know-how was taken with this particular individual. Market barriers to mitigation, supply-oriented barriers to mitigation, and certainly timing issues that impact the mitigation of damages. That was a pretty quick primer on our damages, lost profits aspect of our practice. I'm going to shift things over to Brad. If you have questions, you can probably grab Brad after the presentation. He'll be here all day. If not, feel free to email us on that aspect. But I'm going to turn things over to Brad to talk about shareholder divorce actions.
Yeah, Melissa's actually got a much more interesting afternoon than the rest of us. She gets to go to Vegas this afternoon. So I will be here all day, though, so that'll be fun. So shifting gears, looking at another litigation scenario where financial experts can be involved. Shareholder divorce, shareholder oppression. As Melissa said, when we get a case that is a shareholder dispute, shareholder divorce, it in many instances can reflect what you see in a marital divorce. And what is the reason for that? All right, you're looking at, you've probably been in business with somebody for a very long period of time. The relationship between the shareholders is not just about the business. Their families likely know each other. It's very multifaceted and complex interaction between the shareholders. So for that reason, they can be very emotional, they can be very contentious. Again, shareholder disputes is what we tend to call them, but really shareholder divorce is more accurate name for what we're looking at. So what are the causes of shareholder divorce? If we could go all day on the causes, we would have slides, into this afternoon, the number of different things that can cause these issues. Again, the long-term nature of being shareholders in a business can allow things to fester for a long period of time. But some of the common ones that we see, some of the most pertinent ones, personal use of business assets or income. We see this almost any time we see a complaint come across our desk or we get involved in a case. It can be large, it can be small. So if we're talking about misappropriation of income of a business, maybe truly just theft of money from a company by one shareholder, that's a big deal. It can also be as small as personal use of business assets. So they're using a work computer to do personal business. So no matter what the kind of keystone issues are, we almost always see this as kind of thrown in there, some type of personal use of the business assets or income. Personal behaviors that are either civil or criminal in nature. This could either be inside the business or outside of the business. When you think about inside the business, fraud, tax evasion, those big picture things that are truly spun off from the operations of the business, but you also have things that could be impactful to an outsider's view of the business because of actions of the shareholder. Harassment, whether that's in the workplace or outside of the workplace. Even a DUI can bring negative press upon a business and start creating those tensions between owners of a business. Use of business to advocate for personal interests. Financial success or distress of the business is a big one. Distress is probably a little bit more straightforward. If the business is not doing well, that creates stress. Stress creates tension. Tension can create the shareholder disputes. But Also, when businesses are doing well, we can see a similar scenario where maybe there's arguments as to what to do with the profits. Should we bonus the employees, give it back to them because they're the ones helping us generate that income? Should it be for the management group? Should we take distributions? Should we put it back into the business? If the larger the number of shareholders, it's more likely that we're going to have different opinions as to what to do with a healthy, profitable business, and can create tensions even though the business side, the operational side itself is actually thriving. Shareholder equity owner freeze out. So that's shareholder oppression. When we think about the acts of a majority shareholder that are intended in some way, shape, or form to oppress a minority shareholder, oftentimes aim to force a minority shareholder out of the business. That's a shareholder oppression scenario. And we talk about some of the valuation issues. If it's just a shareholder dispute, maybe they're arguing versus oppression, those are handled two different ways when we're actually brought in to value and ownership interests in the business. So what are some resolutions? So to the extent that we're not able to solve these kind of issues in the normal course, what are some ways that we can resolve the issue? Probably the most common and most straightforward is an equity owner buyout. So simple in that everybody's able to go their separate ways. You figure out what is the appropriate price for which you can buy out an owner. That owner gets to liquidate their ownership interest in the business. Business can continue, the remaining owners continue to operate the business, and we can all go on our own way. That to say, it's not necessarily the easiest way, right? Value is obviously critical in that situation, and determining what is an appropriate value is difficult. Also, you're going to have different views as to what is a fair value for that minority share, for that shareholder that is exiting the business. So not only value in terms of what is the dollar amount that the ownership interest is worth, but how will that owner get paid? Is it going to be accumulation of other shareholders directly buying that ownership interest? Is the company going to redeem those shares and put them in treasury? And how quickly can that owner actually get paid for this? So a number of different aspects are involved there. Even when it comes to, if we were talking 3 or 4 years ago, say there's an agreement that they'll pay out a shareholder over a period of time, whether it's a redemption, whether it's other shareholders. The interest rate on that paper that exiting owner is taking away is likely not something that was going to be something at issue for the last 10, 12 years. But the volatility just in interest rates in the last 24 months can create nuances that even going beyond just the value of the ownership interest itself, a lot of different aspects can start becoming more and more contentious. Outright sale of the business. Now, this may seem extreme, but there are many cases where this is truly the only way that we are going to be able to solve the problem. So let's talk about what are some scenarios where that may happen. Think about if you have two 50-50 owners. It's more difficult to buy out a 50% owner than it would be if you had 100 1% owners, right? Just by sheer magnitude of the value of that ownership interest in the company. So you might have shareholders that are not liquid enough to be able to buy out a 50% owner. The business may not be able to fund that buyout in terms of a redemption. So it truly may be the only way to settle things is to sell the business to a third party and allow those original shareholders to go their own way. You see it a lot in real estate holding companies. So a company that owns a rental property, the value of that business is really in the value of the property itself. So if you have an owner that needs to be bought out, how do we become liquid to be able to buy that owner? We sell the property, we no longer have a business. So although it feels a little bit extreme, there are definitely situations in which that is the only scenario that we can get at. Obviously, advisors can come in to help the owners figure out the best possible way to sell it to a third party. You might be able to sell it at a higher price to a strategic buyer. And then tax strategies can be employed. You're going to hear from a number of wonderful tax professionals here today who have seen these types of sale processes, whether it's some type of contentious or whether it's for retirement, but can definitely advise is the best way to structure those for a tax favorable strategy. Arbitration and mediation. So now we're looking to third parties to come in and help the owners settle a dispute. So arbitration truly is a third party that will be the decision maker. And in many instances, the goal here is to try to be efficient without going through the court system. arbitration in a lot of ways can feel like you're going to court. You know, you have a third party that is going to hear both sides. There's likely an operating agreement, a shareholder agreement that can kind of dictate what the third party is able to listen to, what that process looks like. But in many ways, you often have two shareholders that are each going to retain their own counsel. They're going to make arguments to this third party, and then the third party is going to be the one that ultimately determines what either the value is, what the structure looks like going forward. One of the biggest cases that we had in terms of a shareholder dispute, the company that we were valuing was worth somewhere between, I think, 450 million on our side, or 900 million if you were selling to a third party, as the other side was arguing that. And it went to a third party, and that third party was dictated, or it was directed to that third party from the partnership agreement that there's no middle ground here. It's either 450 or it's 9 something. And went through the process, felt very much like a trial, albeit not in a courtroom, it was in an attorney's office. And at the end of the day, the third party agreed with our value more than they agreed with the alternative value. So stakes can be high in those kind of situations. Alternatively, mediation is bringing in a third party, but that third party's goal is not to be the decision maker. That third party is there to try and get the various parties to come to some type of agreement. So this can look, again, a lot of different ways. What we've seen as successful is a mediator. Usually attorneys kind of do this type of work, but they'll bring all the parties into their office, keep them in separate conference rooms, and then throughout a day just go back and forth. What if I can get them to agree to this? Would you be acceptable to, you know, maybe moving the needle a little bit over here, trying to get the parties to agree? So you are looking to a third party, but that third party is not necessarily a decision maker. They're trying to bring everybody to some type of consensus.
I would add that mediation is a much better route, and most agreements, shareholder agreements, buy-sell agreements, will require mediation or a form of that. Arbitration, you don't see too much in agreement, but mediation is huge, and it's typically, actually, it's a judge that presides over these. And what factors into attorneys using a mediator is actually their ability, what's their percentage of cases that they were able to settle. And because if they're not able to settle, they're not going to waste, attorney's not going to waste their time, potentially, unless, attorney has other goals in mind. But that's a very important factor, is that mediator is motivated and determined to have both sides come together. So it's not just going from one room to another, hey, what do you want? What do you want? They meet with both parties. They actually they build their own position independently based on what both parties are, information that they're given. And that information, probably 99% of the time, is from the financial expert in the room. We kind of command, our side of the case in terms of the way that we see the financial aspect. They developed it independently. They kind of know in their own mind. They used to split the baby, and now you have judges that are a little bit more sophisticated, and they work towards an end. And their goal is to hopefully paper it by the end of the day. And a lot of our mediation has been successful, but we've had a couple that had to, because I think in orders of magnitude, had to go on to court.
Yeah, in terms of where mediation tends to be more successful, the further you can get the contentious shareholders apart from one another seems to be better. So oftentimes in that scenario where you're in an attorney's office in two different conference rooms, they'll get the valuation professionals from each side in the same room and say, hey, you guys don't have skin in the game but for what your opinion of value is. Where do you agree with things? Where do you disagree with things? Where can we try and find some type of middle ground? As we say, again, every presentation that we've done in the last decade has been specifically about valuation. And every time that we talk about valuation, we talk about it's an art and a science. So there are different valuators, different appraisers can view certain aspects of business valuation, certain aspects of the operational side of a business different ways. So there's definitely areas that can be agreed to, things that can move the needle one way or another.
Yeah, and I think it typically when we get in that room, the experienced valuators understand, or the experienced financial experts understand what those differences are, and we're able to concede things or get a better understanding and go talk to, our side and, okay, how do we see this getting to an equitable, and I use that term lightly, resolution.
Okay. So the next one, resolution in the courts. So we say that courts don't want to address disputes among shareholders, and this is because there's very few tools available for them directly. You can't just go to the court and say, we're upset with one another, fix it. Generally, what we've seen is when these kind of issues go to the court, it's for proper interpretation and proper, application of some type of agreement. So shareholders will come together at the beginning of a business, put together that shareholder agreement, operating agreement, whatever it is, partnership agreement, and to the extent that that was agreed to and everybody was on the same page, that is fully enforceable when these types of issues come up. So when we see these go to the courts, it's not for the court directly to determine what is the best interest for the company. It is enforcement of the legal document itself. So one of the things, we do a lot of these presentations for attorneys, and one of the things that we always stress is oftentimes when a business is started, shareholders are in a much better mood, right? So they're going to come together, come to an agreement. That is a critical point in the business in terms of making sure that everybody is on the same page and protected when and if some issue may arise down the line. So it is not uncommon that whenever these issues arise and we get the phone call, what they're doing is they're opening a drawer and dusting off an old document that they haven't looked at for 20 years, and they don't necessarily know what it says, but it is authoritative in terms of how these situations will need to be played out. And the courts can get involved to make sure that those are interpreted the proper way and then that they are applied in coming to a resolution. So courts only become truly involved in limited situations, and the few tools that they have outside of enforcement of those legal documents can include, it's uncommon, but can include appointing a custodian to step in for the management team if the owners are the management team and they can't move the business along. Also, we've seen it in Pennsylvania. The courts can order a judicial dissolution of a business. So you could have a business that other things aside from the owners not getting along could be a profitable operating business. The courts may determine that you have to cease operations and dissolve the business. So many things that you want to consider before it ever gets to that point, but it is something that we have seen, and we've seen in Pennsylvania.
Yeah, we weren't part of that case. It's actually rather local, but it was a LLC, 50-50 partners. It was profitable, very profitable. They were in a deadlock, and the court sometimes gets to a position where they're forced to just render an opinion that says you're going to liquidate a profitable company. They don't like to be there, but they have gone there, and they've gone there in our jurisdiction. Most likely, it's a buyout. We've had cases where we were working on, and we had no faith in the internal records that the majority shareholder had custody of, and we explained that to the attorney with whom we were working. And that was brought forth to the judge. And as Brad said, a custodian was appointed to go in and look at the underlying documents. We had a pretty egregious one over the summer where I testified in Philadelphia in an effort to plead to bring that custodian in. We ended up winning because it was pretty much a no-brainer, very, very egregious situation. But those things have to, outside of these disputes, and when Brad start talking about items, acts of oppression, those are real. And if somebody is back there, as he said, cooking the books and doing some things that they shouldn't, and we have to try to place a value on that, and we don't have reliance on those underlying documents, we'll urge the court to come in and appoint a custodian to go in and parcel through that. And we had a case, Brad, how long? It took the guy 18 months maybe to go through the books and records, to just get it into a place where Brad and the team can start doing the valuation procedures.
So what is the role of a financial specialist in these scenarios? So the type of dispute, the facts and circumstances of the dispute are really going to define what the role of the financial specialist is. But it can have many layers and involve various specialties. So the first one, obviously our bread and butter, is valuation of the ownership interest. So bring in a credentialed expert that has the ability to opine as to what is the value of the ownership interest. But it can go beyond that. Forensic accounting, I don't need to explain to the people in this room, but we know, looking if there's any type of issues with whether or not the financials truly represent the position of the company, you can call in a forensic expert where, unlike an audit that tests the financials or looks at the financials on a test basis, they go in and look at all the detail of the transactions that go through to hit the financial statements to give some level of comfort as to whether or not there are any issues there. But then there's various other consulting roles that financial experts can play. Again, I kind of mentioned it before. One of the things that we see whenever businesses are started, as attorneys are drafting the documents, they'll give us a call and say, can you take a look at this section of the agreement that speaks to valuation in effort of, or in advance of what might happen if there's ever some type of dispute, and can you interpret that to the shareholders so that they know what they're agreeing to, because again, it's likely that if something comes up, they're going to be pulling this out of a drawer years down the line. So we can weigh in on those kind of legal documents. We can help in settlement negotiations, various other types of litigation support, strategy, those kind of things. So what are some valuation-specific issues? Obviously, valuation is a critical piece of any of these disputes. Reason being is how much of an impact it has on all the parties involved in the situation. So failure to consider some of the nuances can create a lot of issues. You need to have an intimate understanding. Valuators need to have an intimate understanding of the financial and operational aspects of the business. A lack of that quality valuation can be a costly misstep in a few different ways. First and foremost, what is the resultant judgment of the value of the ownership interest? If it is poor quality work and the value is either inflated or deflated, that's going to be to the detriment of a party, whether it's the company, a majority shareholder, or a minority shareholder. But also, if it is a poor quality valuation and the answer is really meaningless, the parties may have to go and hire an additional appraiser. So not only is it in the resultant value determination, but the time spent and cost associated with that time spent trying to figure out what the value is in itself. So it is critical to engage a qualified valuation expert, somebody that's credentialed, somebody that has experience in this realm. We see a large number of cases where, for purposes of trying to save a buck, shareholders will go just to their regular CPA who doesn't have any experience doing it, and that can work. Oftentimes it becomes more expensive going that way because you need to have somebody else take a look at it down the line. So some of the main valuation issues, again, the purpose of the valuation is going to drive a lot of the foundational, fundamental aspects to valuing an ownership interest in a business. So an expert's going to be engaged to help resolve the dispute, assist in offering a reasonable price, or aid in negotiations, or determine what it is the value, have an independent appraisal of the value of that ownership interest. The existence of a buy-sell agreement is huge, or some type of buy-sell clause within an operating agreement, a partnership agreement, a shareholder agreement, because that should speak to how the ownership interest should be valued. And it should have been agreed to by all parties, knowledgeable parties at the onset and the signing of that document. So it will speak to a number of these foundational items that are critical for valuation. Valuation date we'll talk about, but that's the effective date of the analysis. That's very important because value changes over time. So if you bought a stock right before COVID hit and you bought a stock immediately after everything shut down, it's two different values, right? So value changes over time. So the effective date of valuation is critical. It determines what information can be included in the analysis, that this idea of known or knowable information for the valuator as they're going through their efforts. What is the premise of value? Are you valuing the business on a going concern? So if it's a profitable operating business, are you valuing it as such? Or are you valuating it, or are you appraising it on a liquidation scenario? That is, if we are truly looking at the balance sheet and what could we get for the assets and what would it take to settle the liabilities, two different premises. What is the standard of value? We have a couple slides on this, but this is the definition of value. So if you get a report where an appraiser says, my opinion of the value is X dollar amount, it's really meaningless until you understand what is the definition of that answer that they're solving for. And then what are the resultant valuation adjustments, discounts, premiums that are applied? Usually that's going to be resultant of other factors, the purpose of the valuation, the methods used. So looking at standard of value, so again, this is the definition of value. There's two main standards when we're looking at these type of disputes, shareholder oppression. Fair value versus the fair market value standard. The fair market value standard, for anybody that's been here before, that's the one that we talk about the most because that's the one in 80% of the engagements that we undertake. It's under the fair market value standard. It's the most common standard for estate planning. It's generally one that's referred to whenever you're setting up these organizational documents. We use it for other types of engagements, employee stock ownership plans. Has a very long history and well-accepted definition, both by the IRS and as well as in the valuation community. But the fair value standard is the standard that most states lean towards whenever there's some type of shareholder oppression case, including Pennsylvania. So Pennsylvania uses the fair value standard to resolve these types of disputes defined in the Revised Model Business Corporation Act. And it says some courts do not equate fair value to fair market value. That's generally the case in Pennsylvania. They look at it as two separate and distinct values. And I do like this chart that we pulled together to compare the two. The fair market value standard being on the right side of the screen. Again, the most common standard that we operate in. What is that hypothetical sale price for the ownership interest based on a willing buyer, a willing seller, both fully knowledgeable, neither on any compulsion to buy or sell. Alternatively, looking at the fair value standard, again, this is the standard that is used as more of an equitable standard in these shareholder oppression cases. If it's that oppression scenario where one shareholder is allegedly being harmed, fairness to that shareholder is considered. So generally, you're probably not looking at a willing seller. Other than the fact that the shareholders are not getting along, maybe that the exiting shareholder would not otherwise want to be selling the ownership interest. Similarly, you may be looking at an unwilling buyer. Again, but for an issue between the shareholders, you may have a majority owner that wasn't looking to buy out a partner. So not always going to be a willing buyer or seller. And the idea of fairness to a minority shareholder that has been harmed is taken into consideration, primarily in excluding any specific adjustments that would bring you down to a level that is fully minority, because that is to the detriment of that oppressed shareholder. So when we talk about valuation adjustments, valuation discounts, in the estate planning realm, this is something that we try to leverage, right? The discount for lack of control, discount for lack of marketability, applicable to minority ownership interest under the fair market value standard of value. These adjustments are really the result of other aspects of business valuation. And in an estate planning scenario, you try to gift an ownership interest in a business where these discounts are applicable. In a shareholder divorce, shareholder oppression scenario, it's going to be based on what the ownership interest is already that the exiting shareholder owns. So what is the standard of value in the engagement? So whether it's an agreement that dictates a certain standard of value, or whether it is judicially determined to be fair value in Pennsylvania. What are the characteristics of the ownership interest? So if it's a majority ownership interest versus a minority ownership interest, what are we solving for based on that specific ownership interest that we are valuing? And then what is the indication of value from models that are applied? So there are a number of different models and methods that are available to us in our toolkit to appraise a business. Each one of those provides an indication of value that will be on a certain level of value. So the applicability of a discount is going to be the result of the method applied so that the answer that you're looking for aligns with the standard of value that is used in that engagement, as well as the ownership characteristics of the specific ownership interest that you are valuing. So again, when we talk about valuation adjustments, buy-sell agreements will speak to the standard of value, or should speak to the standard of value as it relates to an appraiser coming in and determining what is that dollar amount. It should speak to fair market value, inclusion of discounts if it's a minority shareholder. Absent any of those government documents, the state, the jurisdiction in which the business is in is going to carry the day. Again, in Pennsylvania, it's that fair value standard. What generally that has been understood to be in Pennsylvania is if it's a minority shareholder and we're valuing them on the fair value standard, we don't take those discounts for lack of control, lack of marketability, because, and again, in a oppressed shareholder scenario, they would be they've already been harmed allegedly, and now they'll be harmed again by taking those discounts to decrease the ultimate purchase price of their ownership interest. So that wraps up everything that we have today. I'd point out that half of our practice is this litigation, some type of financial expert litigation, half of our practice being full valuation. But there is a Venn diagram there of where that work sits. So a lot of the litigation that we do does touch on the valuation side of things. We wanted to try and bring a little bit more light to that side of our practice, but know that anytime you have a client, anytime within the businesses that you work in, you have any type of questions, please feel free to give us a call. We're always willing to hop on the line to talk about valuation-related topics. So with that, I just want to say thank you again, everybody, for being here. We appreciate your attendance, and I hope you enjoy the rest of the day.